Works for me. Okay, this is George F. Ide Family LLC versus Meridian Charter Township and GS Speedway Builders, Inc., docket number 21-114 CB, and this is the time set for hearing on defendant Meridian Charter Township's motion for summary disposition under C4, C8, and C10. And I will take appearances first from the parties. We can start with the plaintiff.
Good afternoon, Your Honor. Melissa Hagan.
Good afternoon, Your Honor. John Brennan on behalf of Meridian Township.
Good afternoon, Your Honor. Kevin Rorgan on behalf of GS Speedway Builders.
Okay, I'm going to hear from Mr. Brennan in just 1 minute because obviously he represents the moving party. But I'm going to do something I don't often do, and that is talk a little bit first because I want to focus you on where I'm seeing this issue. I'm not so concerned about the arguments that come after the subject matter jurisdiction argument. I'm more concerned with the subject matter jurisdiction issue, and I would like the attorneys, if you would please, to concentrate more on that than the things that come after it. And in that regard, my concern is not so much about whether an appeal can be taken after a preliminary plat approval or whether it has to be taken after a final plat approval, because this case does not claim to be an appeal. According to the complaint, it's coming under the general jurisdiction of the circuit court to provide declaratory or injunctive relief. So to me, what I see as the issue on the subject matter jurisdiction issue is whether appeal is the only recourse, the only method of review, or whether a party could also, or in lieu of, invoke the general jurisdiction of the circuit court. And I'm going to talk a little more and focus you even more, I hope, because the township says that based on Reed, an appeal is the sole remedy. I just will tell you up front that I reject that as far as Reed goes, because that language in Reed is based on the superintending control court rule, and that court rule in particular provides that you can't seek superintending control if there's another remedy available. So that's where that language comes from in Reed. This obviously is not about superintending control. So I'd like to know from the township what the authority is that would support a ruling that appeal is the only recourse, the only avenue of review. And then likewise, I think the plaintiff sort of dances around the issue and argues that there's been no final decision yet. But if this isn't an appeal and you're not claiming it's an appeal, then nobody cares whether there's a final decision yet. If you're invoking the general jurisdiction of the circuit court, and if it were an appeal, the plaintiff's argument that there's been no final decision yet would doom its own case. So I would like the plaintiff to address that, and to clarify whether you are in fact seeking this as an original action under the general jurisdiction of the circuit court, and if there's any authority for you being able to do that in lieu of an appeal, or whether an appeal again is sort of the exclusive avenue of review. So I know that was lengthy. I don't usually do that, but I have studied this, and that's where I would like to hear your focus. So with that, Mr. Brennan.
Well, thank you, Your Honor. I guess I would have to, I guess I'm a little bit unsure about what the court's issue is with Reed, but I guess I could also cite to the Carlton case where the court clearly, I thought at least, makes it clear that if there is an appeal, if there is an appellate avenue to have a issue reviewed, that avenue needs to be exhausted before taking collateral approaches to have the very same issue brought before the court in terms of its general jurisdiction. And I guess I would use as an analogy, situations where there is an attempt to collaterally attack any kind of a judgment that should have been appealed first before. So if I lose a case, for example, and I've got the ability to appeal it, but instead I decide to file a different lawsuit invoking the court's general jurisdiction when I should have appealed that case, then that case is final and I shouldn't have, it's binding on me. It's really a matter of res judicata. And so I guess I would rely on res judicata principles in that sense, that if they had an ability to appeal, and I don't think anyone disputes the notion that I'd had the ability to appeal. Well, I guess we kind of dispute whether or not, and I can get into that issue as well. But as far as we're concerned, and what we've briefed is that the preliminary appeal, the preliminary plat approval, there was a final based on that, and under the authority that we've set was an appealable order or appealable decision. Not appealing it. Yeah, go ahead.
But wait, I'm sorry. But didn't the township acknowledge in the brief that there is no provided for appeal in the Land Division Act or in the applicable ordinance?
Yes, and that's why applying Carlton Sportsman's Club and Reed, that there is, if the township or the statute does not specifically provide for an appeal process of one sort or another, then under that authority, the appropriate appeal route is to have it reviewed on appeal as an administrative decision. So that's how the puzzle sort of fits together as far as our argument is concerned. And so in that regard, it's like any other administrative decision. In other words, there's an appropriate appellate avenue to have that decision reviewed. And instead, what they want to do is to have this court sort of step into, and I don't know whether if it's not an appellate review, I don't know what it is. I guess they're asking the court to sort of do it to make the determination in the place of the township. In other words, substitute your honor's discretion for that of the township in terms of whether or not this particular plat should be approved, which I think would be inappropriate. So the basic result is that this is akin, or at least parallel to, what happens when when a party fails to take advantage of an opportunity for appellate review, doesn't do that, and then tries to reach out to another jurisdiction or another, and whether it's in Michigan or someplace else, depending upon the facts of the case, to have another court sort of collaterally attack that whole process. And that's basically what we're saying here. Now, there has not been an approval of the final plat of the area of the phase that's under consideration here, that's in dispute. So, and we've acknowledged in our reply brief that, and we have done it in the original brief, but it wasn't brought up. But there's no problem with that in terms of that avenue. If they want to appeal the final plat approval, there may be different standards as far as we're concerned as to whether or not this particular issue should be revisited, and we'll address that if that is ever appealed. But the fact of the matter is that they do have that route, and that route is not ripe yet because the final plat approval has not taken place. And with regard to whether or not the decision was a final decision, in other words, the decision to approve the preliminary plat was a final decision, we've pointed out that the statute itself refers to a final approval of the preliminary plat. But more importantly, in terms of what happens on, when a preliminary plat receives final approval, the developer or the proprietor is the statute term used by the statute. The developer has basically a vested right. They've got the right to rely on the determinations that have made with regard to road placement and other general conditions that are in that preliminary plat. And the developer spends considerable resources, and the township is planning on the developer complying with those particular provisions in the preliminary plat when they come to the final plat approval. The process isn't restarted all over again. So you have both the township and the developer that made the application relying on the fact that this much has been approved and this is what you're going to build upon. If that's not a final decision and appealable, then what you have is 2 years later, or in our case, we've had several, as the honor is aware, we've had, I believe, 8 extensions, right? So now you've got 8 years of these extensions where this right has been vested. And then development finally happens with regard to the final plat. It goes through the final plat approval process, which basically is designed to see whether or not the final plat comports with the preliminary plat and whether other aspects of the final plat are appropriate. And all of a sudden now the suggestion is that we can go back and open up all the way back to the preliminary plat approval and say, well, that was wrong, or that's inappropriate. We had to throw the whole thing out. And you've got either somewhere between 2 and 8 years worth of reliance out the window. So if there's going to be a review of the issues that were appropriate for preliminary plat review, that should take place at the time or near the time of the preliminary plat final approval. And that time should be within the appeal period for having that administrative decision reviewed. And that makes sense with regard to the process. And it also makes sense with regard to what's vested in terms of the developer's rights, because the statute itself says that township cannot make any changes, that the proprietor has the conditional right to rely that those general conditions, which include road placement, road configuration, aren't going to be changed by the township. Now, it is true that they can be changed. The developer, certainly in the process of going to a final plat approval, can ask to have that changed due to whatever the changing conditions might be with regard to the development. And the township can either decide to approve or not approve the suggested change. But that's a different scenario from having the township say, oh, I know it's been 2 years, but we've changed our mind. Nothing's changed except that we don't like our decision we made 2 years ago. So we're going to change it now, and you have to go back to the drawing board. And that's what the statute says you can't do. So if that decision can be appealed, in our case, 8 years later, it really turns that provision on its head and basically says that, well, the township cannot change any of the general conditions unless it decides to, which of course is absurd. So from that perspective, and I think it also ties into the notion that if there is a problem, whether it's a violation of the statute, not giving appropriate access or what have you, at the time of the preliminary plat removal, that needs to be reviewed. And I'm not suggesting that changes of circumstances that happen might not give an appropriate consideration to issues at final plat approval. But there has been no changes since the preliminary plat approval. Nothing's changed with regard to the ownership of the property. Nothing's changed with regard to the surrounding circumstances. Nothing within the application for the preliminary plat, anything substantively has changed. So there really isn't any reason to revisit it and say, well, you could have appealed it, you didn't appeal it, but now you can appeal it only sort of through the side door through invoking the court's original jurisdiction through a declaratory action. So I know that's what your Honor wants us to focus on. I think the part 1 and 2 are related in that regard because the vested rights that come with the township's inability to change things, I think explains why that is a final decision and explains why jurisdiction is limited.
All right, thank you. Ms. Hagan?
Thank you, Your Honor. Let me just start with where Mr. Brennan left off. The statute is referring to Section 120. First, it doesn't grant any vested rights. It grants conditional rights, and they're temporary, only 2 years. So let me just make that record straight. But Your Honor, this is an original jurisdiction action. The authority for that is the Altman decision, the Supreme Court decision, which challenged the very suitable access that we're talking about in this case and did so through an original action. The problem with having to appeal a grant of a preliminary plat is that the suitable access statute hasn't even come into play. Your Honor, the suitable access statute, section 182, only applies to final plat approval. So there is nothing at the preliminary plat stage requiring the proprietor or the township to provide suitable access. So it would be an appeal of a non-decision. It would be an appeal of something that hasn't yet happened. What we've done here instead, Your Honor, is in accordance with the Altman decision and also in accordance with the Carlton Sportsman decision, we have filed this original action to have this court declare the actions thus far of the township and the proprietor to be in violation of the Land Division Act and to enjoin further violations. Because if the township, as it's indicated is set to do, grants the final plat approval, well, then they're going to start selling lots, and they're going to sell the lots that block the access between the I family property northern portion and Sierra Ridge Estates number 4. So, Your Honor, it's not so much that the court would have concurrent jurisdiction. We believe that the court does not have appellate jurisdiction. That appellate jurisdiction is, in fact, limited to final decisions, and that one has not happened here. For all the reasons that we stated in our brief. I would address any questions that the court has.
I don't really have any.
Your Honor, can I make oh, I'm sorry, Mr. Rogan.
Yeah, I was going to let Mr. Worrigan talk because he filed in a concurrence.
Thank you, Your Honor. I just want to address what I think was the court's question, a couple of points. First of all, clearly the plaintiff's complaint is not styled as an appeal. It's not an appeal of a decision. So that's the answer to that question. And the defendants, my client and the township, have argued that the claims that the plaintiffs have raised here can only be raised in the context of an appeal. That's the argument that we have made. And I think that the issue then becomes a sub-issue of that then becomes, well, has a final decision on this preliminary plat or on this plat generally under the Land Division Act, has that been made? And the plaintiffs insist in their briefing and here today that no final decision has ever been made. And Your Honor, as Your Honor pointed out at the very get-go, if that's the case, and if truly there has not been a final decision made on this plat, then that's fatal to their claims altogether, I think. And I think Your Honor said that if there hasn't been a final decision, then they cannot invoke this court's general jurisdiction to get a declaratory and injunctive order that tells Meridian Township or any other administrative local agency how they ought to finally make a vote on a plat, which, when the Land Division Act clearly gives the sole jurisdiction to do those things to those local administrative agencies. So if the plaintiffs are admitting that no final decision has been made, then I think that's fatal to their case. If a final decision...
Wait, I'm sorry. Why is that? Because I wasn't implying that. I think a final decision is necessary to an appeal. But I didn't say that I thought a final decision was necessary to an original action. And why would that be? Why would a final decision be necessary to an original action? I get declaratory judgment lawsuits all the time that they don't involve per se final decision.
Sure. But Your Honor, you have to look, but what are the plaintiffs asking this court to invoke its general declaratory judgment jurisdiction to do? And what they're asking this court to do in their complaint is tell Meridian Township how they have to vote on a plat, or tell Meridian Township that a plat is in violation of the law. they can't do that outside an appeal process, Your Honor. And I know, and for the reasons that Mr. Brennan went through, and I think articulated well, but the Reed decision, as well as the cases that the Reed decision relies on, makes it clear that you can't do that outside of an appeal, because an appeal under the constitutional provision of Article 6, Section 28, an appeal covers a claim that the decision that was made is not supported by material, substantial, or competent evidence in the record, or that the decision was contrary to law. Those are the two bases for an appeal. And the case law and the court rules, as the Reed case looked at the plaintiff's complaint here and said, okay, this ought to be an appeal, but what you've done instead is filed a complaint for superintending control. The court rule makes it clear that if you have another available remedy, that you can't bring a claim for superintending control. So your claim for superintending control is out, because it should be covered by the appeal. The court also goes on in Reed to say that the additional counts, which were claims for due process violations and claims for nuisance per se, are also prohibited by the fact that they should be brought under the guise of an appeal. And the authority for that is, as the Reed court noted, is the Court of Appeals decision in Krohn v. Saginaw. It's Krohn v. Saginaw, 175 Mishap 193, a 1988 case. And what Krohn says is that if you have claims that go to the heart of what an appeal would be, and that are issues that would otherwise be subject to direct appeal, those claims have to be brought in your appeal, not separately as a separate action. And for that reason, the Reed court further dismissed the plaintiff's claims in that case of due process violations and nuisance per se, because they were tied up with the issues that should have been appealed. Here, the plaintiffs are claiming the exact same thing. They're either making a claim that the decision to approve this plat is not supported by the evidence, or they're claiming that decision is contrary to law, contrary to a provision of the Land Division Act. Clearly, those are issues that would go to the heart of any appeal, and therefore their attempt to make an end run around an appellate process by invoking this court's general jurisdiction is it's either premature, or this court lacks the subject matter jurisdiction to do it.
Your Honor, can I respond to Mr. Rorgan briefly? Sure.
I guess it's a little, I guess I went a little out of order here, but go ahead, Ms. Hagan.
Thank you. Mr. Rorgan's argument kind of asks that we be able to put the toothpaste back in the tube. I mean, if you can't challenge except through an appeal, then I have to wait for the final plat approval, a final decision. And at that point, the proprietor has likely constructed the roads. In fact, I am well aware that Mr. Fedewa is ready to, start building out there. So the Land Division Act isn't set up that way, that the neighboring landowners have to take that risk and have no possible recourse at all until final plat approval. Now, the Krohn decision, Your Honor, that's a zoning case, and it didn't involve plat approval, and simply doesn't apply here. And the fact that Reed relies on the Carlton Sportsman case, again, that's the law that says a final decision is a decision from which there is no further review. There's no further action. There's nothing else that's going to happen on that decision. That hasn't occurred here.
All right, thank you. Mr. Brennan, now your rebuttal.
Thank you, Your Honor. A couple things. First of all, if it is true that the issues that Ms. Hagan refers to cannot have been reviewed at the preliminary plat approval stage, which I disagree with, but taking it for sake of argument, then IDE is too early. there hasn't been a decision. There hasn't been a final plat approval of this particular area. So why are they in court now, sort of anticipating or what Meridian Township might or might not do with respect to that request? And it's absolutely premature. Now I've heard that, well, we're afraid that Mr. Fedover might go about selling lots or what have you. Well, I mean, any decision that's made at, for example, circuit court level on a judgments can be executed immediately unless they're stayed. So that parallel exists here as well. There's recourse if I wants to take it during the course of the appeal process to protect the status quo if they think anything is going to happen to ruin that. The roads are not built overnight, and so there's the issue is whether or not that can be reviewed in a timely fashion. I believe it can be, if that's again, and that's assuming, only for sake of argument, that decision hasn't already been made and doesn't need to be remade. But in the event that it has been made, and we contend that it has at the preliminary plat approval stage, then it is too late. And I think that the points that I made before is it makes sense. Now, I talked about a vested right. I didn't suggest that it was vested for any longer than 2 years. It's vested as a conditional right. What are the conditions? The conditions are you have to meet the provisions of the final plat approval process, which is somewhat detailed. So that's no surprise. But that promise, if you will, from the statute, that prohibition against the township from doing anything to change the general conditions, which is the whole point of a preliminary plat approval, to understand what the basic structure of this plat is going to be. If that's to mean anything, then that has to be appealable. Otherwise, it really doesn't mean anything. It just means, well, we'll try not to do anything in 2 years, but really in 2 years or within the 2 years, we can do whatever we want. If the developer comes for final plat approval within those 2 years, that developer is relying on the fact that preliminary plat approval is not going to change. So it seems to me that is a final decision that needs to have been appealed. And I think the statute supports that. Obviously, there is no case directly on point, or that would have been cited all over the place by everybody. But the fact is that the language in the statute, which refers to final approval of a preliminary plat, and I realize that the terminology final on one hand and preliminary on the other can sort of be somewhat confusing in terms of labels. That's nobody's fault here. But the fact is that there is a final approval on what does that mean. That has to mean something in the statute. The words in the statute have to be given meaning. No term in the statute can be nugatory with regards to its meaning. And the same thing with respect to the 2-year prohibition. If that really can be changed by a declaratory action or otherwise, if the township can be forced to do that, then what does that mean in the Land Division Act? How much meaning are we going to give those words? They don't really mean anything because they don't have any teeth. And I think that's an important thing to keep in mind with regard to our initial argument. But even if we're wrong, then this case is premature. So I guess our position is, Your Honor, they're either too late or they're too early.
Okay, I understand that argument completely. And I'm going to start by talking about something that isn't even essential to my ruling, and that is this argument that there's been no final decision because there's been no final plat. I do disagree with that. For an appeal, you have to have a final decision. An appeal is not a final plat. It's the decision that has to be final, not the plat. So, if there were an appeal here, and here's the glitch, everyone acknowledges the ordinance doesn't provide for an appeal. The Land Division Act doesn't provide for an appeal. But if there were an appeal here, I would fully agree with the township that it's the decision approving a preliminary plat that is a final decision and appealable, as well as a decision approving a final plat. But they're all final decisions. They're just not final plats. But that's not the concept here. But to me, the question is whether, given that there is no provision for an appeal in the ordinance or in the Land Division Act, can you bring a declaratory judgment action? And I completely disagree that you need a final decision to bring a declaratory judgment action. You need an actual controversy. And there is clearly an actual controversy here, and that's not what's at issue here today. So I go back to the question of whether, and I know, you know, or the township wants to say this is really an appeal, but it very clearly is fashioned as a complaint for declaratory judgment and injunctive relief, invoking the general jurisdiction of the circuit court. So the question is, can you do that where there's no provision otherwise for an appeal, or do you have to turn this into some kind of an appeal, which if that's really what this was, I agree, it would be premature or too late, either way. But anyway, I'm looking for authority on whether you can bring a declaratory judgment action where there is no provision for an appeal. And I'll go back to Reed. Reed just does not help us in this regard, in my opinion, because Reed, even though it's unpublished, I would use it as guidance if I thought that it was applicable and helpful for guidance. But again, as I've already indicated, the language in Reed, they wanted to amend their complaint to add a superintending control provision and make it a complaint for superintending control. And the court said no. And they cited expressly to the court rule, which addressed this issue that I'm raising in this case. And that basically said, no, superintending control is your last resort. If you got something else you can do, you do something else. And that, you know, has always been the case with superintending control. So Reed just doesn't apply here to tell me that you have to take an appeal and that's your only recourse. So the township says, well, if you can appeal, then that is your only recourse. But of course, I go back to, again, there is no, and I think this is an important, essential point in this case, there is no appeal provision in the ordinance or in the Land Division Act. So then I turn to, well, I could turn to Altman, which I understand the point. It was an original action. I don't believe it holds that, though. That's not what was at issue on appeal. So it doesn't provide me with binding authority to say that you can bring an original action. So Meridian Township says Carlton does. And I'm going to talk about Carlton a little bit. I know everybody knows this, but I'm going to say it anyway, because I know these attorneys are very adept and well-versed in this area of the law. But I'm going to say it anyway, because it's how I work through the meaning of Carlton and how it applies. So ordinarily, when it comes to zoning ordinances, a township board will make a decision, and then the aggrieved party goes to the zoning board of appeals. And then if the party's still aggrieved after the zoning board of appeals, then the party may appeal to the circuit court, and the decision of the zoning board of appeals is considered a final decision. So in Carlton, the plaintiff was denied a special use permit by the township board. However, the ordinance under which they were denied did not have that required provision that would have allowed an appeal to the zoning board of appeals. So the question was, if you don't get that intermediate stop at the zoning board of appeals, can the township board's decision be considered a final decision that is appealable to the circuit court? And the Carlton court said yes. Okay, that makes sense, but it doesn't say that an appeal is the only avenue or recourse for review. It just doesn't say that. All Carlton said is that when an appeal to the zoning board of appeals is not provided for, then you can go directly from the township board decision, treat it as a final decision, and go right to circuit court. So as far as authority goes for bringing an original action, Carlton doesn't help me either. I fall back on the general jurisdiction of the circuit court to hear a declaratory judgment action or injunctive relief. And, that's, to me, that's authority enough when there's nothing else that says you can't. But, there's something else that I would note that I think is relevant that was somewhat touched on today. And that is there really is a legitimate interest in letting local townships interpret and apply their own ordinances, and then in keeping the review of that limited to the standards of review that you would do when there's a that normal progression from township board to zoning board of appeals to circuit court. Because, you want the township board who knows their ordinances, who knows their issues, to be interpreting and applying that. And that's why we have that rule on appellate review where the court doesn't substitute its judgment for that of the township zoning board of appeals on review. That makes good sense. But I think it's really important that in this case, and this is unlike Carlton, the township isn't interpreting and applying their own ordinance. They're interpreting and applying the Land Division Act. So I think that's even more reason why that the proper exercise of jurisdiction is the general jurisdiction of the circuit court to hear and decide declaratory judgment actions and injunctive relief. So I have to, for those reasons, reject the subject matter jurisdiction argument. And then we have the related argument that, boy, they couldn't even get relief because the plaintiff can't get changes once the plat is approved. Well, of course, with respect to the fourth phase, we only have the preliminary plat approved. And in response to the township's argument, I can only say, of course, the plaintiff isn't barred from getting changes. I won't even address the fact that the township has taken the position in the past that they can make changes from the preliminary to the final plat, but instead I think it's more appropriate to even focus on the language of the Land Division Act in section 120. So it's true that when a preliminary plat is approved, the proprietor has a 2-year-long conditional right that it will not be changed. But I can't read in any common understanding of conditional, I can't read that language, conditional right, to mean an unlimited right. And if the 2-year-long conditional right to no changes was intended to last indefinitely, then of what use at all would the process of the final approval serve? And the final approval has to be, is a new process from the preliminary approval, where the plat has to be submitted to all the pertinent agencies all over again, and they have to approve it. So of course they can make changes, or why else would they have to approve it? At the very least, they could reject it. And we know that because the statute says that they must reject it if it isolates other lands from existing public streets. And finally, that very language about isolating other lands appears in regard to the final plat approval in the statute, but it does not appear with regard to preliminary plat approval. So I can only conclude that, of course, a final plat can differ from a preliminary plat. And of course, there is no bar to changing a preliminary plat. Then the township says that the complaint fails to plead facts that are sufficient to state a claim. Specifically, the township says that the only allegation on the access issue is in paragraph 22, and it's no more than a recitation of the Land Division Act. There's no specificity requirement here because this is not a pleading of fraud or mistake. And paragraph 22 is sufficient for notice pleading to notify the defendants of the nature of the claim. I think that can be explored further in discovery or by other civil procedure avenues. So I would reject that as well. And then finally, we get to really a factual dispute over whether the I property is or is not isolated from existing public roads. And this is where the plaintiff says that judgment should enter in its favor under I-2 because its expert provided the only credible expert evidence on the issue of road access, and that would be Daniel Capone, a licensed professional engineer. And then the township presented the affidavit of Mr. Kieselbach, Kieselbach, who's the Meridian Township Community Planning and Development Director. The plaintiff says Mr. Kieselbach is not an expert. He hasn't considered any topographical or wetlands maps, and he's only drawn lines on a map without regard to suitability or feasibility. I'll defer for now on declaring whether Mr. Kieselbach is an expert or not, but I would note that contrary to the plaintiff's assertion, examining a map is personally observing facts, so I would reject that, and he doesn't need a license to be an expert. But again, I'm going to defer on that because it's not ready for decision today. But even if he wasn't an expert, I can't, in the context of a C10 motion, weigh Mr. Kieselbach's affidavit against Mr. Capone's affidavit. And I think that's particularly true here because it's not access. There is like thumbs up, there is access, thumbs down, there is not access. It's suitable access. And that's going to take a trier of fact or a context in which facts can be found in order to determine whether there's suitable access. And I don't think it's appropriate for a C10 motion. So I would deny judgment in either side's favor on that. So I'm denying the township's motion for summary disposition under C4, C8, and C10, and I'm denying the request for judgment in plaintiff's favor under I2. And if someone wants to submit an order that reflects that, I will sign it.
I will do an order, Your Honor.
All right. Thank you.
I'll circulate that to council before presenting it to the clerk.
Okay.
Thank you for your time today, Your Honor.